Near St. Paul's Cathedral, in a maze of ancient narrow back streets, stands the office of what has rightly been called the conscience of the legal profession. Eternal vigilance is its watchword. It is founded on the principle that if a changing society is to remain coherent and its members are to live peacefully together, then it is vital that the law should adjust and remain accessible to all. Its name is justice. (1956). The world was shocked when the Soviet Union invaded Hungary. Parliament was in turmoil when British, French and Israeli forces secretly and illegally invaded Egypt to take over the Suez Canal. The newly formed United Nations was trying to intervene in both disputes. And as stories began to emerge from Hungary of secret trials, memories were revived of the trial of Nazi war criminals 10 years before. It was all going wrong. Within a month, another international scandal occurred. In South Africa, the government arrested more than 150 members of the Black African National Congress. Treason trials began, and unfair procedures were adopted to ensure guilty verdicts. These events brought to a head discussions that had been going on here in the heart of the temple over the previous 2 years. A group of lawyers had been meeting in the chambers of barrister Peter Benenson here in Mitre Court. They had been discussing what might be done on an international level in such circumstances.
Peter Benenson was certainly the initial the prime mover at the beginning.
He was certainly very active in justice, was partly doing all kinds of things behind the scenes. He was very interested in the South African trials. In fact, I'm pretty sure he went there. He was a perfect gentleman.
Peter Benenson's informal gatherings came to the conclusion that a new organization was needed. His first job would be to ascertain the facts of events such as those in Hungary and South Africa. On the Hungarian invasion, Sir Hartley Shawcross, who had prosecuted at Nuremberg, prepared authoritative opinion on the breaches of international law. The United Nations was approached. Gerald Gardner caused a stir when he went to observe the South African treason trials. They lasted some 4 years and effectively began the anti-apartheid movement. The second priority for this group of concerned men was to find an international voice for their opinions. So they decided to join the International Commission of Jurists, then based in The Hague. Funds were sought for this unique enterprise from members of the legal profession. Membership fees were organized, and so in 1957 the Justice Organization was born.
The original office was in Crane Court, number 3, Crane Court, which is just off Fleet Street.
It was pretty Spartan accommodation, you know, a couple of rooms on the first floor, that sort of thing, because we hadn't got any money much to pay rent.
We were a kind of legal aid service, but in order to keep the thing going, there was a sort of social side to it as well. We used to have dinner dances were arranged at the Savoy.
Many members of the legal profession were happy to support an organization that criticized the legal systems in other countries. Here in Crane Court, Justice produced a series of reports on international law. But when Justice began to scrutinise the English system, it was much harder to raise funds. After a year, the membership was just 375 and the income a mere £615. Once Justice was up and running, Peter Benenson decided to move on. In 1961, he founded another great institution, Amnesty. This became the international organisation he had always wanted. After a year or so, the office moved to this end of Crane Court, and that was where a series of influential reports began to emerge. In the early 50s, Parliament's priorities were naturally still focused on recovery from the Second World War. The system of justice that the new reform group was taking on had seen little change in the previous 2 decades. The long list of legal challenges that Justice was now suggesting underlined the need for reform. The first important report by Justice, published in 1959, concerned contempt of court. It found the law unsatisfactory in several important respects, particularly concerning charges of partiality or corruption against a judge. During the following year, Parliament used the Justice recommendations as the basis for the Administration of Justice Act. Although the authorities might dismiss research by other pressure groups as being partisan, it was much more difficult to dismiss research from Justice, and this was because of one significant element in its formation.
Justice was an all-party organisation. That was said to be one of its strengths, and we had representatives of all political parties and none.
Within a few years, Justice moved to a block of offices just opposite the Royal Courts of Justice, and they had a bit of luck. The Mobil Oil Company bought the site for redevelopment and provided Justice with larger offices just over there on the corner of Chancery Lane and Carey Street. It was there that Justice became firmly established for 2 decades.
We moved to Chancery Lane courtesy of this oil company that took over and redeveloped Clement's Inn. And this was quite palatial in comparison to Clement's Inn. We had 3 rooms, and one of them was a very big general meeting room where almost everything happened. One was a little room to the side where the director sat, and the third was where we had some administrative staff. And we began to expand. We raised some money, and I got an assistant, a legal assistant, and we got three administrative staff. We used to have American interns, and I remember one director from this program coming in and saying, "Oh, this is what I always imagined an NGO should be. Packages falling off the walls, every bit of space occupied." He looked at the intern and said, "Enjoy this experience, lad. You'll never get anything like this in the States."
International work had always been the original purpose of Justice, and that has continued. But over the next 30 years, the organisation was mainly to concentrate on domestic issues, and that was largely the work of one man, Tom Sargent.
Paul Johnson, in his book These Offshore Islanders, has a chapter on the law in which he says that the English are the most conservative nation in Europe and lawyers our most conservative profession. They have clearly shown that they are incapable of reforming themselves and their legal system. This means that we need a revolution in society's attitudes to the law, headed by the media, by independent-minded parliamentarians, and those members of the profession who have managed to keep alive a real passion for truth and justice.
This was a remarkable and yet a typical statement by a man who at the time had effectively been employed by English lawyers for the previous quarter of a century. Tom Sargent became Secretary of Justice in 1957. His salary was £500 a year. He held that position until 1983. Under his guidance, over the next 25 years, justice truly became the conscience of the system of justice.
The many hazards of an accusatorial trial will probably meet with cold indifference on the part of authority, even when there are clear indications that there has been a miscarriage of justice.
Tom was imbued with the spirit of civil justice and criminal justice, for that matter, and was, I think, a friend of Peter Bennison's, and quickly took up the position of the first Secretary of Justice.
Beneath that sort of urbane and kind exterior was a very steely man, a man who was very much informed by his Methodism and by the principles that Methodism for him represented, and a man who very, very rarely gave up on anything. Perhaps his most enduring quality was his persistence. He rarely, if ever, admitted defeat. He was not a lawyer. He had suffered at the hands of lawyers, and so he had a natural sympathy with those who claimed that they too had suffered at the hands of the law and lawyers. And this was really what inspired his casework. I mean, I think he did the casework in spite of the Executive Committee and the Justice Council at first, rather than with their encouragement. But they did come to see that the cases were an important element, an important, we'd call it today, data source for the other work that justice was concerned with.
He didn't wear his Christianity on his sleeve, but he was a deeply committed Christian, no question about that. And he was, of course, honest, completely and utterly honest. Everything he said, it may not have been legally accurate, but he believed it to be true. Tom would never do anything, as it were, disreputable or dishonest or untruthful, as he saw it. He wasn't a lawyer, but had he been a lawyer, he wouldn't have been Tom Sargent. And he was very hostile to what one would describe as the legal establishment and the legal system, the criminal justice system. And he was absolutely convinced that a lot of people were wrongly convicted. And he dedicated his life, really. He came into the law and justice, as it were, relatively late. But he was absolutely dedicated to this work.
When I joined justice, I think the mentality of the senior people in the legal profession was that the British legal system was probably the best in the world, and if miscarriages of justice occurred, they were very, very few in number, and it was worth the odd rotten egg in order to maintain confidence in the system. So it didn't matter too much if the odd person suffered an injustice, and it wasn't really the responsibility of the courts or officialdom to make a great deal of effort to put that right. And those members would be both academic lawyers, solicitors, barristers, and retired judges. Serving judges didn't usually sit on committees. And I think in many cases Tom found them a bit trying because they were a bit technical. But he was very, very useful in ensuring that they got access to particularly casework data. Tom was also very, very good in public, and so he was very much the public face of justice.
Tom Sargent's dedication and assertive manner was what led successive governments to take note of justice's ideas.
Justice was non-party political, which was very important, but it was also non-political with a small p. It was about getting people who were involved in the profession, who were involved in legal services, to recognise that where things went wrong, where people suffered, and generally that, of course, is the public, they played a part in that because willy-nilly they were working the system, they were providing the service, and they had a responsibility to try to ensure that the service was as good as it could be.
The Justice offices here at the back of the Royal Courts of Justice produced many major reform papers over the next 30 years. But perhaps none was more far-reaching and important to British life than the creation of the Ombudsman. One of the leading proponents of the initiative was Sir Louis Blom Cooper.
There was a reference in a textbook, I think written by an academic from Manchester University, where there was a mention of the Ombudsman, which was a Swedish concept going way back to the 18th century. I think I picked up in the newspaper that in Denmark and in Norway they were on the point of considering emulating the Swedish model. I wrote 2 articles in the Observer in May of 1959. Tom Sargent had managed to persuade Sir John Wilde and asked him to do a report for Justice on the Ombudsman system, and that led to the politicians becoming interested. My recollection is that both the Prime Minister of the time, Harold Macmillan, and the leader of the opposition in the Labour Party, Harold Wilson, both of them showed interest, and it looked as if at some stage in the near future it would be on the political agenda and get statutory recognition.
And I think there were a lot of people at that time, and I hope still are, who were concerned when things went wrong and who were willing to give their time, their expertise, and in many cases their money to trying to put it right. There were committees that looked into things like legal aid, because even in those days legal aid was under attack, and so there was a question of how better to fund legal services. There was the issue of how to resolve disputes. We looked at insolvency. The Insolvency Act of 1986 was pretty much born as a result of some initial justice research. I mean, a variety of areas often brought to the attention of justice by its members. There were issues around nationality, immigration, where we set up committees. Now, of course, not all those committees led to changes. Some of the proposals they made at the time were very far-reaching. For example, Justice advocated a Ministry of Justice some 15 years before it was introduced. We advocated things like a contingency legal aid fund, which evolved into the no-win, no-fee basis, but I don't think that's as good as the fund that Justice proposed. Other areas we looked at included improving sentencing. One, to me, a very sensible proposal was the day fine system, where for magistrate court offences, people would not pay a fixed penalty or a fine. They would that would be expressed as a number of days of their earnings, which meant that if you were poor, although you paid a smaller amount in actual terms, in terms of a percentage of your income, you paid the same as a rich person. These seemed to me to be proposals which were radical at the time and still seem radical now.
After the success of the work done on the Ombudsman scheme, the annual Justice reports began to have increasing influence on politicians. Tom Sargent organised committees to deal with the many ideas that came to his office from his members. He supplied the research database on which they could ground their arguments. The committees were always formed of eminent lawyers from all areas of the system.
Cases often illustrated what was wrong or what appeared to be wrong with aspects of the legal system. These very often led to the setting up of committees, and we tried to use bills or other aspects of parliamentary procedure to make the changes which the committees recommended. There were some standing committees. There was an administrative law committee, a criminal procedure committee, civil justice committee, and they met with experts specifically from those fields and came up with a lot of very practical, small improvements which would make the law function better.
One of Justice's earliest reports was later to have a great impact on British justice. In 1961, a Justice Committee examined whether the Court of Appeal was adequate to deal with possible miscarriages of justice. It was the first time in 50 years that anyone had seriously questioned the infallibility of British justice. It was a subject close to Tom Sargent's heart.
I can conceive of no greater and more prolonged mental torture than for an innocent man to feel the police net closing round him, to protest his innocence to deaf ears, to be confronted at his committal proceedings with alleged admissions he never made or with evidence he knows to be false, to arrive in court after months of waiting and there find himself defended by a counsel who knows very little about the case and a judge who backs for the prosecution. His chances of acquittal in such circumstances are very slender, as are his chances of a successful appeal.
Gradually, Justice became not simply a reform group, but the very conscience of the legal profession. Stories of injustice naturally create an emotional response, particularly in the case of miscarriages of justice, where men and women are seen to have been falsely imprisoned. Some members may have wished it otherwise, but this emotional appeal was presented to the public in a forthright manner. Tom Sargent's indignation was clear for all to see.
3 years ago, 2 young girls were walking with a dog on the outskirts of an Essex town when they were joined by a man who chatted to them and showed them a path into a wood. He suddenly seized hold of the younger girl, threw her to the ground and raped her. The elder ran off with the dog to get help. In the course of house-to-house inquiries, suspicion fell on a young man called John Woolcott, whose blood group matched that of the rapist. He was called in for questioning and to be put on an identification parade, but for fairly obvious reasons this never took place. For both the girls had described the man's height by comparing him with their daddies, which worked out at 5'8.5" whereas Woolcott is a veritable giant of 6'8". Now, John Woolcott was a man of low intelligence, so when the police promised to help him if he admitted the rape, he agreed and signed a brief but inaccurate confession. His trial was something of a charade. The girls' statements were read out, but neither of them gave evidence. The judge's only comment on the issue of height was, "One of the girls, or was it both of them, said the man was shorter." He made no comment, as he should have done, on all the other discrepancies. And this was unfortunate because Woolcott only had an alibi provided by his family.
Throughout the late 70s and early 80s, some important books presented Justice's argument to the general public. Many of these books were written by journalists whose newspaper groups launched campaigns to free the people whom they believed to be falsely imprisoned. By the start of the 80s, these campaigns had become so persuasive that they were taken up by the television companies. Hundreds of thousands of pounds were now devoted to researching cases from the Justice files. Money was the one resource that Tom Sargent had never had available to him. Now that he did, the results were spectacular. Cases such as the Guildford 4 and the Birmingham 6 became notorious. Some of the convicts involved became household names, their faces on our television screens, their families frequently and stridently condemning British justice. It became a general and, most significantly, a populist campaign. In the public's mind, these programs proved what Tom Sargent had claimed for a quarter of a century. He became closely linked with one particular BBC series. This television series was to run for 25 years. The programs caught the attention of the nation. There was a media feeding frenzy when the first conviction of a rough justice case was quashed. This was the case which demonstrated to many that the system for dealing with alleged miscarriages of justice had to be changed. Justice was now deeply involved in shaping those changes.
Oh, it was very much involved in that, because if there was an allegation of miscarriage of justice, all that could be done was you had to make an appeal or a reference to the Home Secretary or the Home Office, and they had a unit, a small unit of civil servants, and they would look at the allegation, or at least so they said, but they virtually never suggested or advised the then Home Secretary or the relevant minister to take any action. So nothing was done, and it was extremely difficult ever to get a case back, or a case either back to the Court of Appeal or to take it there really in the first place. And it was really, government did not wish to suggest that the judges or the juries had got it wrong. I think the political view was, that's a matter for the law and the lawyers and the judges and the juries. It's not a matter for the politicians. And indeed, we don't really ever want politicians interfering in the process of the courts. So there was a real dilemma there. But there was no doubt about it that the civil service played a straight bat all the time, virtually. And that was clearly an unsatisfactory state of affairs.
In 1982, Tom Sargent handed over the running of justice to an experienced professional campaigner, Leah Levin. Together they set about summarizing what was going wrong in a new report on miscarriages of justice. Tom died in 1988, the year before the final report was published. As a result of the Justice Report, many top lawyers met at the Law Society to discuss the idea of an independent tribunal to consider miscarriages of justice.
And it is the consequences of the Stafford test in the cases already...
In the chair was a retired appeal court judge, Lord Justice Lawton. The main speaker was the leading solicitor of the day, Sir David Napley.
Upon what possible basis can anyone in common sense seek to justify the upholding of a conviction on such highly technical grounds, whilst there is a real possibility that had the appellant's counsel not been incompetent or mistaken or even honestly misguided, the citizen would have gone free? A second example concerns the admission of fresh evidence. The Court of Appeal will rarely hear this if it was available at the trial but not utilized. How can that be justified? The essential and indeed only question should be whether an innocent person has been convicted. A panel of lawyers and specially selected laymen should be appointed For preference, experienced and independent investigators should be required in appropriate cases to ascertain the facts. Clearly, it should be the function of a review body to consider such aspects, since the humanities and justice must both, under those circumstances, take precedence over legal technicalities in disregard of the susceptibilities of the legal profession and even the judiciary.
And it does seem to me that this is a very strong argument for going back to David Napoli's proposal of the court of last resort, an independent body, not part of the regular judicial system, which has the time and should be properly financed and staffed to be able to carry out independent investigation work properly on the very small number of cases which I believe call for it.
It is ironic that the strongest call for an independent tribunal to deal with miscarriages of justice came just a year after the death of Tom Sargent. Within 2 years, a Royal Commission had been set up. Its recommendations led to the creation of the Criminal Case Review Commission in 1997.
All of these and many more issues still need...
Such was the impact of the reforms that the Lord Chief Justice took the unprecedented action of publicly praising justice for its contribution to this change in the law.
The Court of Appeal on a reference by the authority. This is the most important single change proposed by the Commission with a view to preventing, or at least speedily rectifying, any miscarriage of justice. It is not the only measure aimed at achieving that result. Perhaps of equal importance is the cluster of recommendations in Chapter 2 of the report concerning the training of police and the supervision of investigations. They may not, read individually, make a dramatic impression, but taken together with the Police and Criminal Evidence Act and the recommendations about disclosure, preparatory hearings, forensic science evidence, and the review authority, they make a formidable combination of measures against possible miscarriages of justice.
The Criminal Case Review Commission has sent thousands of cases back to the Court of Appeal for consideration. Many innocent people have been released from prison. The Commission is now so much a part of the system of justice that it's hard to imagine a time when such a safeguard was not in place. Leah Levin had the difficult task of taking over from Tom Sargent in 1983. Unlike Tom, she was a professional organizer, having worked in the human rights area of the United Nations. She came into office with systems dating back to the 50s.
It was still all kitchen table stuff, because everybody worked for almost what today would be regarded as nothing. But it wasn't of consequence. So, I mean, you know, salary and all that kind of thing was what there was. And you took it as it was. And the atmosphere in justice was one where you really had access to wherever you wanted access. Certainly in the legal world. You had the cooperation of your membership. It didn't matter, you know, a barrister sweating away the whole days really come at the end of a day to sit in for a couple of hours on a little committee producing a kind of a strategy that justice wanted to work to promote in whatever the area was. That was the sort of time when the sort of real change, or the seeds of change were planted. We were coming to the end of Tom's era and the case era, yeah. And the large office where Tom held court, and the wonderful big table around which all the committee meetings took place. I know Tom was quite perturbed when I said I was moving into the small office. He said, "You can't work from there." He said, "You have to be inside the big office with Peter and with whoever else is there." We agreed that Tom would carry on because he wanted to with a number of the cases. We had 2 volunteers in the office who were doing cases. Peter Ashman would deal with the cases, and a number of of other outside people, barristers who were doing cases. We would work with them, or they would work with us rather. I did not involve myself in the actual casework. Justice had to take a good look at itself, and then we set up on that basis. We set up two different things. The one was a committee to start raising funds because we were clearly outgrowing where we were, and the second one to actually review the work we were doing in order to develop a strategy for how to go forward. And I proposed that we invite Professor Roy Good to be the chairman of that committee, and it was so agreed, and he then undertook that, and a total review of Justice's work across the board. So that was the moment of change.
More than a simple reorganization, it was the end of an era. The men and women who had founded justice were being replaced by a new, younger generation. Justice's successes in the first 40 years had firmly established it as the conscience of the system of justice. It was time now to move on to fresh challenges. And the greatest of those would be the incorporation of the European Convention on Human Rights into British law. The new director was Anne Owers.
Leah had done a very good job. Anne brought a new dimension to things. She, I think, was very much focused on getting justice reorganised, one thing, shifting the focus when the Criminal Cases Review Commission was set up, and building up the staff. Justice operated in the old days with a tiny staff. In fact, there were times when there was the director and there was one legal officer, and then there were one or two secretaries or administrative staff. I mean, so they were getting by with 2 lawyers. And Anne built that up to a point where I think at its peak there were probably 16 or 17 people in charge. There were a lot of lawyers, some permanent, some on short-term contracts, or some volunteers, but she really focused on building up the team.
They wanted someone who could lead justice forward from where it was. Justice obviously had had a huge impact in terms of miscarriages of justice, and of course the Royal Commission was being set up, the Runciman Commission, so that was putting justice's concerns pretty much in the centre. I think it was a question of moving from the production of some very good reports produced by some very eminent lawyers who met together, and actually sort of thinking, well, what's the point, if you like? I mean, and the point is not to produce the report. The point is to make something happen. And in order to do that, you have to, as well as using the skills and the experience of the members of justice, you actually have to have a staff team who's also able to coordinate all of that and work out what happens next and how you follow those reports through. And I think that was the key task in the first instance. I think the second key task was actually, and which followed from that, was finding a resource base that allowed justice to do what it needed to do. And for that, of course, we had the Justice Appeal, which raised £1.25 million, which bought the office that we're now sitting in, which but also allowed a fund there where we could take on staff, and on the back of that we could lever in additional money, additional membership, funds from charitable foundations, and so on and so forth. So a kickstart to do all of that. The head of the organisation was Bob Alexander, not only former chairman of the Bar and chairman of the NatWest in the days when banker wasn't a dirty word, But also I think some of the people who've been with justice a long time, people like Willie Goodhart, who had the courage to actually see the organisation that he really cared about change and support that change. People like Sir Roy Good, who fronted the appeal and who I think many lawyers didn't want to sit next to at dinner in case they got tapped up for £5,000.
Anne Owers not only saw the setting up of the Criminal Case Review Commission, but she also masterminded Justice's significant input to the introduction of the Human Rights Act.
When Justice was set up on the initiative of lawyers in both political parties who cared about what was happening to human rights in Hungary during the treason trials and what was happening to human rights in South Africa during the treason trials there. So this wasn't new work for Justice, but it was work that Justice had always been engaged in, which was now, if you like, coming home. We did quite a lot of work with others before the Human Rights Act was implemented and while it was in development, discussing with government, discussing with lawyers how it might work, how you balanced human rights with parliamentary democracy, how you got the particular model of human rights implementation that we've got now. So there was a lot of work beforehand. And then afterwards, I think there were a couple of key bits of work. One was sitting on the government task force on the implementation of the Act, which was looking at how the various public authorities affected might need to be teed up for this, the work that might need to be done, and also a huge programme of training, which Justice led for the public sector, for the judiciary, for parts of government, for police, for the voluntary sector, a huge training programme which really reached an awful lot of organisations and individuals.
When Anne Owers left Justice to become the Inspector of Prisons, Roger Smith took over. The work expanded yet further.
I came in 2001, and the previous sort of 6 or 7 years had been dominated by the Human Rights Act, arguing for it, seeing it through Parliament, and training on it. And it says I'm the generation that came the day after the Human Rights Act, so what did we do? Well, I went in a way back to the root of it being a general law reform organisation and trying to intervene on an all-party basis at a high level in terms of the legal argument on what I saw as the crucial, or what we saw as the crucial sort of political, legal ideas, issues of the day. We've kept up our interest with the criminal justice, the torrent of criminal justice legislation which the Labour government has bequeathed to us. We've done a lot of work around human rights, broadly defined, i.e. sort of not only just the Human Rights Act as it is, but how it actually works out in practice. Done a lot of work on counter-terrorism legislation because that's been the issue, but also other sort of legal areas. And my own specialism is in access to justice, legal aid, so we've done some work in that.
Today, Justice continues its role of being both conscience and guide in the system of justice. It is now more than simply a think tank that publishes regular reports. The events that are organised from this office also influence debate at all levels. Its files are now voluminous. These shelves hold 60 years of experience from top legal experts. Civil servants and politicians regularly consult with Justice, yet it retains its unfailing objectivity.
And Justice was there at the start, first in the European Court of Human Rights, and then helping to encourage others to approach the courts where they had particular expertise that they could bring before individual judges to help their decision making. Early cases that we were involved in included Hindley, the Bolger case, and a number of others which were about securing an effective approach to due process which took into account all of our international human rights law obligations and the protection of fundamental rights within the common law.
The Director of Justice, Andrea Coomber, is the most legally qualified person ever to hold the position. She was a solicitor and barrister in Australia before she joined the international human rights team of litigators, Inter-Rights. Andrea has worked in Egypt, Switzerland and India as a human rights lawyer, taking on cases of race discrimination, disability rights and gender-based violence. She holds a Master of Law degree at the London School of Economics. In all her speeches, she emphasises justice's independence and political neutrality.
Since Justice was established in 1957, we've worked hard to bring an all-party, non-party political voice from the legal profession on issues relating to the justice system, its operation and the rights of people within it. And it was with that thought in mind that we designed tonight's event, to give our members and the wider legal community the opportunity to speak to members of the last Parliament.
Dame Helena Kennedy chairs the Council of Justice. Events such as the Justice Human Rights Awards benefit greatly from her vast experience. She's a leading champion of human rights and civil liberties. She also tries to give voice to those who have least power within the system. Policies about such fundamental rights are debated at the many speeches and conferences that Justice organises. Lord Chief Justice Thomas spoke at one recent event saying, "For 60 years, Justice has been at the forefront of re-imaging the justice system. We have much to thank it for." The information and ideas in the speeches given at such events are important, but more important are the many discussions that take place after the speeches are over. These are rare events in the world of the law, when the young and the old, the student and the judge can get together to discuss issues. It leads to greater understanding all round.
Well, I think it's really nice that people can come along to these events and have the opportunity to talk to people like the Lord Chief Justice who they wouldn't get on a daily basis, and I think that's what makes being a member of Justice a really unique thing, that you have that opportunity for a pupil to come along and have a conversation with the Lord Chief Justice and go back and tell their colleagues and their friends that they're able to do that. This is quite a privilege, I think.
Justice has come a long way from the cramped offices in Mitre Court and the overburdened rooms in Chancery Lane. The heroes of those days are all gone. Their triumphs are now accepted as the way things should be. A larger and more professional organisation is their enduring legacy. In the past, justice was sometimes ignored and even criticised for its radical ideas. Today, it is often the first voice that is listened to. The justice organisation that has emerged from the difficulties and the problems it has encountered and overcome on its long journey through the past 60 years has proved to be worthy of the men and women who created it.